Now we have a different topic in this video, which is class action suit. Class action suit, we know that class action suit is a lawsuit where a group of people representing a common interest, basically 10 people have a common objection for this, for some kind of act, then they may go to the tribunal, they may approach to the tribunal to sue or be sued. Means to sue or be sued. What can a tribunal can do? To sue or be sued in this case. It's a procedural instrument that enables one or more plaintiff to file and prosecute litigation on behalf of a larger group or class having common interest and grievance. Basically, in the same English, what they want to say is that a group of people can go to the approach to the tribunal for the same offense. Now, so class action suit are expected to play an important role to address numerous prejudicial or abusive act committed by the BOD. Basically, what they want to say in this case that for the numerous prejudicial or abusive act committed by the BOD, the members or may go for the class action suit. Okay, and other managerial personnel, basically it could be a board of director, it could be a manager, it could be a MD, it could be a CEO, it could be any person from a managerial position. As it statutorily recognizes the company, it's also known as representative action. Basically we know the concept, what they want to say is in this case. Now evaluation क्या हुआ इस केस में, that Satyam case was held, Satyam fraud was held in 2009. Then the class action suit concept was introduced in India, because what has happened that in Satyam case, Indian investor would not get the benefit of class action suit, whereas where the Satyam listed in another country, which is, in which country Satyam has been listed again? American depositors. Basically in American there was a concept of class action suit where the investors of basically American depositors were able to receive money in settlement as a result of strong class action framework in US. Then the need of class action suit was felt in India also. Thereafter, Companies Bill 2009 was introduced. In class action suit were included as a measure to be available to the members and depositor. Who can file the case herein? Members and depositor. Class action suit will provide a window to a small shareholder. Basically the group of small shareholders they were talking about. So it gives a window to redress the grievance irrespective of their judicial limitations. Jurisdictional limitations. Basically there is no jurisdictional limitations here. Like if one member or one depositor is residing in Rajasthan and another is residing in Madhya Pradesh, then Madhya Pradesh member could go to can say to the Rajasthan guy that you may go for a class action suit on my behalf. So there is no jurisdictional limitation here. Okay, the class action suit will benefit the Indian landscape on various fronts, on which basically what are the benefits in class action suit they want to say in this case. Here class action suit is the benefit is that the clubbing of similar applications and bar on future litigation. Basically what has happened here, there is a similar application, they basically clubbed it and there is a bar on future litigation. And it also reduces the cost, it also saves the court time. It compensation in case of security fraud, there is a compensation criteria, investor education as well as awareness. Now filing of application before the tribunal on behalf of a member or depositor. Member or depositor any class, if they are opinion that the management or conduct of the affair of the company are being conducted in a manner prejudicial to the interest of the company. Basically what they want to say, it's a prejudicial to the interest of the company or its member or its members or depositor or depositors, file an application before the tribunal on behalf of member depositor for seeking all or any of the orders, namely what are the orders they basically want to go for the court to give them, what orders a tribunal can give to the members and depositor in such a case, in case of class action suit. Then it is a very important thing that what a tribunal can do to restrain a company from committing an act which is ultra virus to the AOA or MOA. Basically वो company को रोक सकते हैं कि there is an act which is ultra virus beyond the articles and memorandum of the company, so that act can be restrained by the tribunal orders. Then second is to restrain the company from committing breach of any provision of the company's. Basically a similar thing, that there is a breach of any provision. They are not doing any ultra virus act, but it's a breaching of any provision of the MOA or AOA. Then to declare a resolution altering a memorandum or articles of the company as void if resolution was passed by suppression of material fact. Means what they want to say, that resolution has been already passed, that alteration of memorandum and articles, that can be void if material facts has not been disclosed and there is a misstatement given to the members and depositors. Then in such a case, whatever be the alteration thing that is company is trying to do in MOA or MOA, that could be void. Basically. Third is to restrain the company and its director from acting on such resolution. Basically, for such resolution, they may court may say that you should not act on such a resolution which you have passed by suppressing the material fact. Okay. Fifth, to restrain the company from doing an act which is contrary to any provision of the act or any other law for the time being in force. Basically, which any provision is in the Companies Act, any provision basically. Any provision company is violating that provision of any other law in the company where it is registered in the landscape. So basically the law of land, they want to say that there is a law and company is breaching that law, it is not as per the provision of such law, then court may ask to the company to restrain that thing, to do not do as such any act which is beyond that act. Basically all law company has to comply with. Fifth, to restrain the company from taking any action contrary to any resolution passed by the member. To restrain the company taking action contrary to any resolution passed by the, basically कोई resolution pass हुआ है उसके opposite में जाके company ने कोई काम किया है, then court or tribunal may stop company to do such. Fifth, it's a G point, to claim damages or compensation or demand any other suitable action from or against. Basically compensation और damages का भी demand किया जा सकता है. There is a 3 cases where demand for compensation or damages can be demanded, can be asked by the tribunal to give who is entitled to get that damages. Here, company or its director for any fraudulent, unlawful or wrongful act or omission or conduct or likely any act or omission or conduct on their part. Basically, director and company directors for any fraudulent, unlawful or wrongful act, they are entitled for any fraudulent, unlawful, wrongful, omission or conduct of any likely or omit. Basically, what they did of any act which is fraudulent, unlawful, wrongful, omitted और conducted in a manner, basically वो किसी चीज़ को omit करना चाहते हैं, ठीक है. तो in that case company or directors are liable to pay the damages. Here auditor including the audit firm of the company for any improper or misleading statement of particulars made in audit report for fraudulent, unlawful or wrongful act. Auditors can also be entitled for any wrongful or improper or misleading statement if they give. Then any expert or advisor or consultant. Any expert is also entitled here. Expert, we need expert for some sort of agreement or arrangement or any company which is we need sometimes expert in this case. Then any expert or consultant for any other person, any incorrect or misleading statement they have given, any fraudulent act they have done, any unlawful, wrongful act, conduct or likely to conduct. It is not that it conducted also, or likely act or conduct on this part. Okay. And the H part is to seek any other remedy as the tribunal may deem fit. Here it is the ambit of tribunal is much wider. That tribunal may go for any other remedy. Tribunal may pass for any other remedy which tribunal may think fit or deem fit. Now, class action suit required number or of members or depositor to apply under section 245. We were reading which section? We were reading section 245 of class action suit. 245. Here, requirement of members to apply. 245 subsection 3, but if you remember that 245 section, that is enough. Then 100 members or not less than such percentage of total members as may be prescribed, whichever is less, or any other member holding not less than percentage of issued share capital as may be prescribed, subject to the condition that the applicants have paid all the calls and sum due on his share. Basically, जो members हैं, what they want to say is that all calls and whatever be the sum due to them, they had already been paid. Then they become member, na? Not they. If there is a partly paid member, then they may not go to file any suit. Here a case study can be formed that somebody has a partly paid up share. Can they go for the class action suit? No. Only a fully paid up shares. Only a fully paid up shares can go for the fully paid up shares members can go for the class action suit here. Okay, 100 members or percentage. Here it is in the case of shareholder. 100 members और उन्होंने कोई percentage prescribe नहीं करी है. Basically that may be a 1/10. I'll go with the middle. I already written here that through module maybe 1/10 or 100 member. If there is a no share capital, then 1/5. Not less than 100 depositor. 100 से कम depositor नहीं होने चाहिए और कुछ भी percentage depositor की जिसमें law में जो भी prescribed है. ठीक है. That probably 1/10 of percentage. I'll let you know in another video. Here, requirement for consideration of application. Effect of admission of application under section 245 subsection 5. What are the effects if anybody goes to the class action suit? Then public notice shall be served on the admission of application of all members or depositors or class any such manner as may be prescribed. There has to be a public notice shall be served on admission of the application to all the members or depositors of the class in such a manner as may be prescribed. As may be prescribed, you know that in the law language we always write it down as may be prescribed. All similar application prevalent in any jurisdiction should be consolidated into a single one. Basically what they want to say is any specific jurisdiction, like for the Rajasthan, and there are multiple applications has been filled, then we have to club that applications and make it a single application. Then 2 class action application for the same cause shall not be allowed. For the same grievance they were asking, and there is a 2 class action suit, then it shall not be allowed. It should be one only. Then the cost of expenses connected to such application for class action shall be defrayed by the company. Here it is important point that whatever be the expenses paying, member and depositors are paying here, it shall be defrayed by the company or any person responsible for any oppressive act. It could be a company, it could be a director, it could be a single person, it could be an expert, it could be an auditor, it could be any person who shall be defrayed the amount of the class action suit. Here what are the important points here? Important points is that other order passed by the tribunal shall be binding on the company and all its members, depositors and auditors. Auditors bind हो गए तो we know ना that court का order थोड़ी ना ऐसे मजाक चल रहा है. So it should be binding on members, depositors, auditors, audit firm, expert, consultants, company itself, directors, other persons associated with the company, means suppliers, vendors, everyone is, this is the order and it should be binding on each person. Then punishment for non-compliance. What are the punishment of non-compliance? There is a punishment of 5 lakh to 25 lakh. Okay, on the कंपनी के ऊपर देयर इज़ अ फाइन ऑफ 5 लाख to 25 लाख एंड देयर इज ऑफिसर इन डिफॉल्ट दैट इट कुड बी 25,000 to 1 lakh. 25,000 to 1 lakh. Then section, any application is found to be frivolous, vexatious, it shall be reason for recording and writing. It should be rejected अगर कोई false information है, ठीक है, then it's not so important. Provides that section, this is both related to, according nothing contained in this section shall apply to the banking company. Banking company के case में there shall be no class action suit. We have to be very confirmed with that. There is a banking company, we cannot go for class action suit in case of banking company. Okay. Section 246 provide for the provision of this section, this both inclusive related to winding up shall apply to mutandis in relation to application made to the tribunal under section 245 और सेक्शन 3 मीन्स कि प्रोविज़न जो है सेक्शन 337, 338, 339, 340, 341 बोथ इंक्लूसिव रिलेटेड टू वाइंडिंग अप शैल अप्लाई इज इट इज़ अप्लाई होंगे वो कंपनी के ऊपर. अब मैं एक बार यहाँ पे पेनल्टीज पर दोबारा रिवाइज करा रही हूँ सारी पेनल्टीज़, और पेनल्टी के लिए हम एक डिफरेंट लेक्चर रखें. विल गो फॉर अनदर लेक्चर फॉर पेनल्टीज ओनली. ओके, बाय बाय.